Students, in the last lecture of CPC, we have studied section number 13 of CPC, which states that normally the foreign judgments operate as res judicata between the same parties to the case, and these are enforceable within India. But if the case of the parties to the case falls within any exception of section number 13, then it will not be binding on the parties and will not operate as res judicata. Now in this lecture, I am going to discuss with you clause number A and clause number B, under which the foreign judgments shall not be conclusive in India. Now let us study clause number A. Clause number A states that where the foreign judgment has been pronounced not by a competent court, it will not be enforceable in India. It is very important that a judgment of a foreign court, to be conclusive between the parties, must be a judgment which is pronounced by a court of competent jurisdiction. Because in private and international law, unless and until a foreign court has jurisdiction in the international sphere, a judgment delivered by that foreign court will not be recognized in India and will not be enforced in India. And a judgment or order which is passed by a foreign court having no such jurisdiction is null and void and cannot be enforceable in India. Now it is very important to see, before a foreign judgment may be said to be conclusive and binding between the parties to the case, the following conditions must be satisfied. The first condition is that the foreign judgment must be by a competent court, meaning thereby that such court must have first of all jurisdiction over the subject matter of the controversy, and apart from the jurisdiction over the subject matter of controversy, it must also have the jurisdiction over the parties as recognized by the international law. I want to repeat it. It must be by a competent court, meaning thereby that such court must have jurisdiction over the subject matter of controversy and jurisdiction over the parties as recognized by the international law. And such foreign court must have directly give the decision by way of adjudication upon the matter in controversy. If these two requirements are fulfilled, then the foreign judgment shall be conclusive and binding, and it will be enforceable in India. Similarly, it is very important to note that a foreign court has no jurisdiction to pass a decree in respect of any immovable property which is situated not in his area or which is situated in a foreign state. For example, if the property is situated in India and the judgment regarding that immovable property is passed by any American court, that judgment shall not be binding within India, because at that time the immovable property is not situated in America. Therefore, that court has no jurisdiction to pass a decree in respect of immovable property which is situated in the territory of India. One more example is also very important to note here. A decree passed by the Ceylon court. Ceylon court is situated within Singapore. Hence, Ceylon court is a foreign court. A decree passed by the Ceylon court in a suit on a contract against a native of India. It means the judgment debtor in this case is a person who is a native of India. But it is also very important to see here that he was not at the time of the action residing in Ceylon. If he was not residing in Ceylon at the time when the cause of action has been arisen, then the court has not the jurisdiction over that native of India, because it is very important that not only the court must have the jurisdiction over the subject matter of the controversy, it must also have the jurisdiction over the parties to the case. If at the time when the cause of action arise, that native of India was not residing in Ceylon, any judgment which is passed against that native of India is a nullity and cannot be enforced by a suit before an Indian court. Now let us discuss clause number B. Clause number B says that the judgment which is not based on the merits of the case will not be binding on the parties to the case, and it cannot be enforceable within India if that judgment has been passed by the foreign court. It says that to be conclusive and binding, the judgment of a foreign court must have been given on the merits of the case. And if a foreign judgment is not given on the merits of the case, then it is not conclusive. It will not operate as res judicata between the parties to the case. When a judgment will be said to be not on merits of the case, where a judgment is given on evidence, then it is deemed to be a judgment on the merits. And if the judgment is not given on the evidence of the parties, then it is deemed to be a judgment not on merits. If no evidence is adduced by the plaintiff and the judgment is given against a defendant by way of penalty and not on the basis of the evidence of the plaintiff, then in that case the judgment shall be said to be given not on the merits of the case. Then it will not be conclusive and binding between the parties. Our Indian courts have the right to examine a foreign judgment to see whether it has been given on merits or not. If the foreign judgment has been given on merits, then it will be binding between the parties and enforceable in India. But if the foreign judgment has not been given on the merits of the case, then it will not be enforceable within India. And it is also very important to see, you cannot say only on the basis that the judgment was pronounced ex parte that the judgment had not been given on the merits of the case, because ex parte judgments are also based on the evidence of the parties or on the evidence of one party who was present at the time when the decision was given. The mere fact of the decree being ex parte will not justify a finding that it was not on the merits, because an ex parte judgment by a foreign court is as valid and executable as a B party judgment. It was held by the Supreme Court of India in the case of Lalji Rama and Sons versus firm Hansraj Nathuram, EIR 1974, Supreme Court 974. There is also one important judgment of Kashmira Kale versus Kishore Kumar Mohan Kale 2010 to AIR Bombay 660. In this case, there was a matrimonial dispute between husband and wife, and both the parties were domiciled in the US, and they last resided together in US. It means the US courts has the jurisdiction over the parties to the case. The wife filed a divorce petition before the court in the US, and judgment was passed on merits. It is very important. The judgment was passed on merits of the case after due service of summons upon husband, and after the husband had filed a written statement in the case. It was held by the Supreme Court of India that the judgment of the court in the US would be conclusive and binding upon the parties to the case, merely because the husband did not appear before the court after filing the written statement would not make the judgment ex parte, and hence not liable to be excluded under section 13 of CPC. So this is something about clause number A and clause number B of section number 13. If you like my lectures and not subscribed my channel till today, then kindly subscribe my channel to get new videos. And for notes on my videos, you can go to lawarticles2020.blogspot.com. Thank you very much.